everybody, I'm Chris, and welcome to Lexplainer, brought to you by Nomad Law. This video sets out to answer the question, can I trademark that? And I phrase the question that way because that's the way I often hear the question phrased. Can I trademark blank? How do I know when something is trademarkable? But let me say at the outset, that entire premise is wrong. Trademark is not a verb. Right? There's no process called trademarking something. Either you've got a trademark or you don't have a trademark. So instead, I'm actually going to be addressing the question, when can you get a US federal registration for a trademark? And to a lesser extent, that's also tied to the question of when can you enforce your rights to a trademark? Those aren't quite the same question, but a lot of the same issues come up. Now, when I say either you've got a trademark or you don't have a trademark, I say that because trademark rights arise from use of the mark in commerce. So in fact, the number one problem that a lot of people have when they want to go out and trademark something, and I use that word with big, bold, scare quotes, is that they're not actually using it as a trademark. Maybe they've, come up with some kind of clever turn of phrase or some kind of an interesting drawing and they want to protect it, but they're not actually selling any goods or services. So that's kind of a threshold question. Are you actually using a mark in commerce in connection with goods and services such that consumers are going to regard it as a designation of origin? But let's say you do have a trademark. What are some of the other problems you might encounter? A big one is that the mark isn't distinctive enough. In trademark law, we talk about a spectrum of trademark strength or trademark distinctiveness. And at one end of the spectrum, you've got really strong trademarks. For example, there's types of marks that we sometimes call fanciful marks. And those are marks that are just made up. Hulu comes to mind. I don't think Hulu means anything. Or Kodak is another just made up word. It's a made up brand. Strong trademarks also include marks that we call arbitrary marks. And those are ones that have nothing to do with the goods and services. Apple is a classic arbitrary mark. Apple is a terrible brand name for apples, but is a great brand name for computers. Down at the other end of the spectrum, you've got what are called generic marks. And those are just the generic word for the thing you're selling. Again, Apple, if you're selling apples, you can't trademark that. Or if you're selling a camera, you can't trademark the word camera. That makes some sense, right? But in the middle, that's where things get complicated. If a trademark has too close a relationship to the goods and services, it might be what's called descriptive. Or if it's just a little bit further away, it might be what's called suggestive. It's got some connection to the goods and services, but not enough to be considered descriptive. Generic marks can never be protected as trademarks, and the USPTO won't let you register them. Descriptive marks, that is, marks that aren't quite generic but still have a very close relationship to the goods and services, those usually can't be enforced either or registered, at least not at first. Descriptive marks can develop what's called secondary meaning, sometimes also called acquired distinctiveness. And that means that consumers have grown so accustomed to seeing that mark in connection with, in particular, that provider of goods and services, that not only is it a description of the goods and services, secondarily, it's also a trademark telling them where the goods and services come from. And that's usually a matter of very extensive sales or marketing and being in business for a long time. For the USPTO, the presumption is after 5 years. A good example is the Container Store, right? It's a store that sells containers, pretty descriptive, right? But they were around for long enough and they poured enough money into promoting the brand and making sure consumers knew about it, so they were able to claim it had secondary meaning and protect it that way. The flip side of secondary meaning is when a word or a phrase starts out as a trademark, but then kind of just becomes the generic term for goods or services, and that's called genericide, but that's a topic for another video. The other reason why your mark might be refused registration is if it conflicts with a prior mark. The USPTO, when it's examining an application, will look at the trademark register, and if there's a prior registration or a prior filed application that conflicts, then they'll reject the new application. And the standard that's used to determine whether two marks conflict is similar to the standard that's used to determine trademark infringement, and that's called likelihood of confusion. The thing to know about likelihood of confusion is that it doesn't require that two marks be literally identical, right? Likelihood of confusion is a fairly complicated legal standard that involves a bunch of different factors, although two of the most important factors are how similar are the marks and how related are the goods or services for which the marks are used. The other thing to bear in mind is that somebody who hasn't registered their trademark but is still using it still might have superior rights to you. And they can actually come along and they can challenge your registration or your application, or they could even sue you for trademark infringement, whether or not you've got a registration yourself. It's just whoever's got prior rights. So the next time you're wondering, can I, scare quotes, trademark that? Those are the questions you should be asking. Number one, am I actually using it as a trademark? Number two, is it distinctive, or is it simply just a description of the goods and services? And number three, does somebody else have superior rights to the mark? For more information, check out our website and blog, or hit us up on Twitter, Facebook, Quora, and all the rest. Thanks for tuning in, everyone.